Yes.
The procedure is you have to ask permission before.
Can I have permission to exercise my rights, please, and document my proceedings?
Well, I'm not allowing you to ask permission.
I just asked for permission. Can I have permission to exercise my rights?
You declared, as I understood.
No, I would like to exercise my rights and report my proceeding.
I misunderstood you. I couldn't hear. It's very loud in here. The air conditioner is going, so I didn't hear the first part. So once we go on the record, Madam Clerk, are you ready?
Yes.
Call the case, State of Wisconsin versus Derek Sprague. Case numbers 24CF127 and 24CF182. Appearances: the state appears by District Attorney Kelly Hayes, who appears in person. Derek Sprague appears in person as well, recognized from the prior appearances. Scheduled date, both matters for initial appearance. Mr. Sprague, off the record with a brief conversation. Do you have a camera with you?
Yeah.
Do you wish to record these proceedings?
Yeah, I do.
All right. The court will grant that. In fact, the court will also record these proceedings on its own. Now, Mr. Sprague, feel free to activate your camera.
Sorry, you're recording these proceedings?
I am.
Oh, I'm going to need to submit a public records request verbally for that recording, and please don't delete it. Make sure it's preserved when you're done.
I shall.
Highly unusual. Not a big deal, but
Mr.
well, since
Sprague, stop talking.
fair enough.
All right. Is your camera going? Is your camera activated?
Yeah.
All right, good. Mine is as well. We're scheduled today for initial appearance. Mr. Sprague, there's been 2 summonses and complaints that have been filed. Have you received copies of those? Mr. Sprague, ask you a question, please answer.
You weren't looking at me. I didn't hear you. The air conditioner is loud.
Have you received a copy of the criminal complaints?
Yeah. Have you read through it to see? Are you good with it?
Ask the question, John. Let me set this right here. I'm going to turn around and take a look at this. Also, for anyone reporting it, I want to make it clear to myself that the material that's being reported is not to be transformed either by analog or digital means, and if it is transmitted, it's to be transmitted in its entirety and not selectively edited. All right, 24CF127, the defendant is charged with two counts. Count 1, felony bell jumping. That's a Class H felony with a maximum penalty of $10,000 on imprisonment not more than 6 years for both. Count 2, misdemeanor bell jumping. That is a Class A misdemeanor with a $10,000 or 9-month penalty being the maximum. Then over in 24127, the criminal complaint lists the following 4 counts. Felony bell jumping, again, Class H felony with a maximum penalty of $10,000 imprisonment not more than 6 years for both. Count 2, obstructing an officer, Class A misdemeanor with a maximum penalty of $10,000 imprisonment not more than 9 months for both. Count 3, disorderly conduct. That is a Class B misdemeanor with a maximum penalty of $1,000 imprisonment not more than 90 days for both. Count 4, misdemeanor bell jumping, a Class A misdemeanor with a maximum penalty of $10,000 and 9 months for both. Mr. Sprague, did you hear me go over the charges with you, sir?
Yep. Are you aware of the working facts?
I'm going through the process, sir. So I've gone over the charges with you, sir. Now, you have the right to have an attorney because these are criminal charges. You have 4 options. First of all, you can represent yourself. Second of all, you can contact the public defender's office to see if you qualify for their services. Third of all, you can try to hire your own representation at your own expense at the market rate. And if you find that you can't do that, but also don't qualify for public defender representation, you can petition the court and possibly have an attorney appointed for you, taxpayer expense. But you have to make arrangements to pay taxpayers back, so it's a down payment, monthly payments thereafter. So my question to you right now, sir, is do you wish to have an attorney in this case?
Are we aware that there's paperwork filed within the last 30 days? I'm trying to answer your question. Are we aware there's paperwork in the last 30 days for a court-appointed attorney?
Mr. Sprague, my question is a yes/no answer.
And I'm answering it the best I can. I have paperwork with this court that I have a court-appointed attorney for cases already here. You signed them within the last 3 weeks, I would say.
Those cases are not here. My question to you today is, do you wish to have an attorney?
Can I have a grant extended to the paperwork I have filed, or do I have to waste more of my time and the court's time to issue redundant paperwork?
Mr. Sprague, the question is yes or no. Do you wish to have an attorney?
Yes.
Thank you. All right, the court will direct Mr. Sprague to contact the public defender's office within 7 days of today's date.
So you're ignoring the part where...
To see if he qualifies or not, and then we'll go from there, depending on whether he qualifies for the public defender's office. If the order for him to contact the public defender's office is going to be a condition of bond in both of these
obstructed, and interfered so much with law enforcement that they had to turn their attention away from the traffic stop cameras. Additionally, when we look at compliance with court orders, he has consistently shown that he is willing to not comply with court orders. We have 3 different cases with misdemeanor bail jumping, and 2 different cases with felony bail jumping at this point in time, showing that he is willing to disregard the fact that he is not supposed to have these cases. Additionally, the resisting or obstructing of officers also leads to a concern that he has an issue with authority as well.
All right, thank you. Mr. Sprague, I'll hear from you as to what you think your bond should be and why.
Well, I would like a signature bond, and I would like the money that was taken from me already for exercising my rights on a public sidewalk in front of my home doing nothing wrong returned to me. I find it appalling and completely disgusting that my character would be assassinated by someone supposedly here to help preserve my rights. I've shown up, as she's shown up, as her own words, I've shown up to every one of these clown shows that have no merit to them. Huh?
It's not a clown show.
And
This is civilization.
am I being censored, or am I allowed to speak how I feel?
No, you're continuing to talk until I tell you you can.
So, trying to make my
Mr.
case.
Sands, please take it up. Go ahead, Mr. Sprague.
Wow. Anyways, as I was saying, this is definitely a travesty of justice in every sense or form. The original cases that she's referring to shouldn't have even been cases, quite frank. Again, I've shown up for every one of these to defend my freedom since
Where do you work?
Northern Wire and Timber Creek.
What do you do there?
Which where?
That's the place you work.
I work at 2 different places.
Oh, tell me which 2 places.
Northern Wire and Timber Creek Resources.
Oh, that's 2 different places.
Yep.
What do you do at those places?
One, I run machines that are about 30 or 40 years old for the newest one. The oldest one is about 60 years old, and there's some of the last machines that are functioning. The new machines are millions of dollars, and they would rather just pay me extra money to keep fighting with it than do so. My other productive contribution to society is I'm a saw filer at Timber Creek Pallet Company. My other productive contribution to society is I'm a saw filer at Timber Creek Resources here in town. Filer. I'm the guy that keeps the saws.
You keep it sharp, you take the tool and make the teeth sharp. Very good. All right, okay, go ahead.
I keep the plant running along with other people behind the scenes. I'm involved. What?
Do you have children?
Yes, I've got one child that's actually the victim because I took an Xbox away.
How old are they?
Going on 19 and then 13.
So you have 1 adult child, 1 minor child. Is that minor child live with you?
Full custody, assuming
Okay,
that
so
this
yes.
doesn't keep
So
tanking
yes,
anything.
yes. Do you have shared placement with anyone of this child? This 13-year-old?
I have sole custody of my child. She lives with me. It would be a detriment to my family life if there's even $1 for a bond for something that shouldn't be.
I got it.
I show up to every place. I would like a signature bond. I have fought for my bond rights multiple times.
It's great you can keep talking, but I'm not going to listen to you right now because I'm reading. All right, the court has reviewed the probable cause sections 24 CF 128, working on 24 CF 127. I have reviewed those. I heard from the plaintiff and the defendant regarding a bond. The plaintiff requested $5,000 to cover both cases with conditions. The defendant has requested a signature bond for these matters, both have stated their reasons. When setting a bond in a matter, the court is to always set bond at the amount that is, well, first of all, go back. When setting bond, bond is always to be individualized. There's no such thing as standard bond. Every case is unique and individualized and is to be considered that way. When setting bond, the court is to consider 3 broad considerations within a number of factors affecting those. First is the need to protect the state of prosecution from improper interference. Attorney Hayes has indicated she doesn't feel that's a concern here. I've read the probable cause section. I don't think that's a concern either. Public safety, we don't have any direct threats or allegations here of violence or domestic disruption. So there is a public safety concern, but not one that necessarily rises to the level of primary concern, which is whether or not this person will willingly submit themselves to orders of the court and comply with those court orders, including orders to return. Mr. Sprague has made mention of his priors. He feels it should exist. The state has prosecuted them. They are currently in the stream of process and end of process. Mr. Sprague has been released on conditions of bond. And the allegations are that he broke them. Now, we're only dealing with allegations. Nothing has been proven in any of these cases that are being proven beyond a reasonable doubt. Mr. Sprague is